Yes.
As I move the motion for leave to file our address after the date ordered by the court, I move that applications in terms of the motion paper and the supporting affidavit. And my lords, as we've indicated, the affidavit in support is sworn to by counsel in this particular case for obvious reasons that appear on the face of it.
My lords, we are opposed to the application. We are opposed to the application, and we are opposing it by virtue of Rule 69C of CI 99, and also, my lords, by reference to the case of Republic versus High Court, Tamale, ex parte Dapem Zobuguna Henry Kalim, civil motion number J5/6/2015, judgment of the Supreme Court dated 4th June 2015. Lords, in that case it was held that the bare fact that an application for stay of proceedings has been filed does not operate as an automatic stay, so no party has the privilege to stay away from proceedings as the applicant did at the court below. Lords, if we look at the affidavit in support, the applicant or the petitioner is brazenly telling the court the reasons why he has refused to comply with the orders of the court. When established practice and the decision of this court is that the mere filing of a stay does not amount or give you the right to stay away from proceedings. Because this is the highest court of the land, and I think that obeisance to the rules and orders of the court are part of our practice. And so far as the positions clearly show that, yes, I chose not to comply with the orders for my own reasons, I pray that this application be refused. Your Ladyship, 69C of CI 16 as amended by CI 99. Yes. The 4B, Your Ladyship, with your kind permission, the court may dismiss the petition where the petitioner fails to file the processes regarding the petition within the specified time. Laws.
No, but we've heard the case to conclusion.
Pardon me?
I said we've heard the case to finality. We are left with only closing addresses.
Yes, my lord, it's part of the processes that we file.
My lords, we are opposed to this application to the extent that the petitioner is not seeking the magnanimity of the court.
But what is he seeking?
He is asserting a right. My lords, the petitioner, my lords,
yeah.
If your lords would refer to paragraphs 10, paragraphs 13, paragraphs 15, and paragraphs 14 of the petition. My lords, of the affidavit in support. My Lord, the petitioner is seeking to tell the court what is convenient for it. So it says in paragraph 10, it would not be ideal for me to have to file a closing address without the testimony of the chairperson. In other words, the court has directed him on the 11th of February that we should all file closing addresses by the 17th. And he elects to tell the court that it will not be ideal for him to file, to comply with the court's order. On what basis can a party tell a court much more the highest court of the land?
It's coming from Leonard friend on the other side. No, it's coming from my Lord. That's the position in the affidavit you are referring to.
Yes. So, my Lord, I'm saying that this deposition is a direct defiance of the court's order.
For leave to file
but it's in the leave, in the application for leave. It's an example of the defiance. My Lord, that's what I'm saying. That it is one thing for them to come to this court contrite, and therefore the court should grant them leave. But they are trying to justify what they did, their defiance of the court's order. So, my Lords, they may be advised to withdraw those paragraphs, offending paragraphs, and just plead to the court that they be granted leave. But this attempt to justify the unjustifiable.
So, comparing with only the depositions, who sees to accept it, right?
Yes, because the application is based on the depositions. So they may choose to advise themselves and withdraw those depositions, of offending depositions. So that, because, my Lords, if this court grants this application on this basis, it will set a precedent. It will undermine the court's well-established authority that a review application is not a stay of proceedings. Secondly, that a party who files an application for stay is not entitled to stay until the court grants it. Those are two very important, principles of this court. And if the court grants this application based on these depositions, it will be undermining those principles. So our view is that it's all fair for the court to grant the applications, but it cannot be based on these depositions. No, it cannot be. And finally, my Lords, they have arrogated to themselves the proposal of when they file. No, yes, I know that will be left to the court. But, my Lord, may you hear me out. They have already had, since the 17th, since the 11th, now it's about how many days? 11 days. And they're asking for a further 72 hours. Meanwhile, we, under pressure, have met the court's order. So if they are seeking the court's leave, they should be filing this thing either by the end of the day or latest tomorrow, my Lord, because they have indicated to your lordships that they already have a draft. Yes, but my Lord, again, like their samples, they are saying this is a draft, so that it will give them the opportunity to go and produce something completely different from the draft.
Order in court, please. Order.
My lords, I will not dignify some of the comments on our conduct. My lord, there have been very serious comments made about our conduct, which I will not dignify with a response. I will not dignify them with a response, because saying that we filed something and then we'll go, I mean, these are serious allegations, but I do not wish to dignify them with a response. That's what I wish to say. I only wish to say respectfully that we have come to this court asking for leave. And in indicating that we are seeking leave, we have adverted in our affidavit to certain factual realities that we have had to deal with. Those factual realities include the fact that we have filed applications for review before this court. Those applications have been heard by this court and they have been dismissed. But we could not have contemplated that those applications would necessarily be dismissed, because we did not believe that there were predetermined outcomes for those applications. That was not the basis on which we proceeded. We did not believe that. And because we did not believe that, we took our time to deal with those review matters in the hope that after the review, we might have the chance to have a witness testify. The court has this morning decided, or this afternoon, the court has this afternoon decided.
My lords, with all due respect, my lords, he can respond on points of law at this stage. No, please, my lord, that is the process I mean.
Please, if the bench wants to say something, you defer to the bench, please.
Very well,
Mr. Kutempa,
very well.
Before he could move the application formally, I had wanted to know whether any of you were opposing it. It is normally done in practice just to, as to manage time. So, well, I anticipated that, well, this is a colleague on the other side who has sworn to an affidavit explaining his inability to do that. He has annexed a proposed, normally we call it a proposed, not a draft, a proposed statement of case or whatever. So I thought that you were not going to oppose. That was why I cut him short and decided to ask whether you were opposing it or not. It is normally done.
Very well, my lord.
Yeah.
And my lords, in the affidavit in support, these clear circumstances in which we have found ourselves have been put before you. As a matter of fact, the paragraph 10 that counsel for the second respondent found so offensive. My lord, with respect, there is no offense to this court in the lawyer saying it would not be ideal for me to file a closing address without the testimony of the chairperson and then have to file a separate further component of should the review application be submitted. That is a very simple statement of the reality that we find ourselves in. So, my lord, rather than get into all these things, we have given an indication to the court, and we say in paragraph 13. The deponent says in paragraph 13, I will crave the indulgence of the court to allow. We did not arrogate to ourselves a time frame. The position is very clear. I will crave the indulgence to allow, and this just gives an indication to the court of a time frame within which it will be feasible to file. How can anybody interpret paragraph 13 as imposing on the court or as not being, as not recognizing what the court's authority in this? The very heading of the application is motion for leave to file. And therefore, we do not see any problem. But my lords, fundamentally, we respectfully say, as in paragraph 15 of the affidavit, there will be no prejudice to the respondent by the grant of this application, especially as they ultimately elected not to adduce evidence in support of their case. So, my lords, we have not had sight of whatever they filed anyway, because I believe the registrar may have been under some instruction, but the registrar did notify us when he was serving other processes that that particular process had been filed but not served. That was notified, and we have not sought to have that because we don't need it. Our legal arguments are not premised on what they have said. Our legal arguments are very clear. And your lordships may note that we call it a draft, my lords, for a very specific reason. Because it is not, as is clear on its face, it is not yet complete. It is very clear it is not complete. In fact, there are gaps in places where certain things are meant to be included. It's very clear. And so, my lords, we've indicated there's a draft, and we've indicated a potential time frame within which the lordships may be willing to grant us the indulgence of filing. And therefore, we respectfully seek the indulgence that we have asked for in our application to enable us to file our closing address. And my lords, may I finally say that when we stand here at the bar, we stand here as officers of the court. We stand here as officers of the court seeking to help the court advance the interests of justice. And in that regard, I believe that a closing address that presents to the court the case of the petitioner in its entirety is something that will be beneficial in the interest of justice.
Mr. Chikata, how do you reconcile this prayer that you are now making to the earlier statement which you made when you were on your feet, that you did not know that there were predetermined outcomes? I heard you clearly.
No, Mr. Chikata, we can play
Mr. Chikata, can you listen to me? When there is intervention from the bench, you have to listen. That is a practice we know from the bar. I heard you. I may not have heard clearly. But what I heard is what I'm asking. Now, how do you reconcile this with the earlier statement that you made, that you did not know that there were predetermined outcomes to the applications that you had filed? That was why you did not file your address.
Yes, my lords, what I
did you say that there were predetermined outcomes?
My lords, no, I did not say it in the terms that you have put it. What I said was that when we made our application for review, we expected that application to be successful. We did not know that there would be a certain outcome. And my lords, we can plead and
Mr. Chikata,
but my lords,
you use the word predetermined.
Yes, my lords, I use the word in the context
if you can explain.
Yes, my lords, I use the word in the context of stating that what the outcome of that was not known in advance by us. So it was not, in our minds, it was not a predetermined outcome. That's the point I was making. For us, it was not a predetermined outcome. That is the fact. And that is what I said. That is what I said. And I believe your lordship has just indicated that that's how you understood what I said. And if your lordship understood it differently, that's certainly not my intent. I stated clearly that for us, it was not a predetermined outcome. And so we could not have, on that basis, prepared a closing address without reference to the potential of that witness being called. We could not have done that. That's a clear indication. And my lords, I mean,
by court. We are of the opinion that the petitioner should be granted leave to file his closing address on or before the close of Tuesday, the 23rd of February 2021, in the interest of justice. Yes. Yeah.
We're grateful.
Yeah. Yes. The petition is adjourned to the 4th of March 2021 for judgment.
My lords, I was actually going to make a preliminary before your adjournment. Is it possible that I may be heard on? Because, my lords,
Yeah.
in terms of the filing of the addresses,
Yes.
I was going to respectfully draw your lordship's attention to the fact that there had been an earlier indication that
Yeah.
you would provide a time
Yes.
for you oral highlights of my lords. May I respectfully finish? That time has passed. I'm aware of that. But my lords, in the light of the new orders, I was going to respectfully ask that after we have filed our written address, an opportunity may be available for your lordships to seek any. My lords, in the petition of 2013, there was an opportunity provided which enabled certain important legal issues that had been raised in the written addresses to be addressed by the bench and the council on both sides. And my lord, I believe that even if it's, for a half hour, as the timekeeper has been rigorously insisting, that enables
Mr. Gigata, we have indicated that we are adjourning for judgment. Now, if we, upon reading your closing addresses, think we want some clarifications, we may come to you. But otherwise, we have adjourned for judgment. Very well.
Order in court. Order, please. Lords, writ number J1/5/2021, Article 64 of the Constitution and Supreme Court Rules 1996 CI 16.
My lords, I take it that you are done with our matters. Very well.
As amended by
There is a contempt proceedings which the court
as amended by CI 74 and CI 99. Amended presidential election petition. Presidential election held on 7 December 2020. John Dramani Mahama versus Electoral Commission of Ghana. Nana Adodankwa Akufo-Addo. Dr. Dominic Akrutinge Ayeni, contempt no. Lord, contempt no present.
Oh, please, yes. Are you represented?
Yes, my Lord.
Council, may you respectfully announce yourself?
Frank Beecham appears for the contender with Koko Bramlabi and David Beecham.
Yes. Ms. Ayene, sorry, Honorable Dr. Ayene, please, you have been summoned here by this court to show cause why you should not be committed for contempt. Yes, because on the 16th of February 2021, we made certain statements which were very, very scandalous of the court.
Sorry.
Yes, we've exercised restraint in invoking our jurisdiction to always be committing people for contempt for obvious reasons. The other time, I think you were here when I drew the attention of Mr. Frank Davis. I think so also, yes, Lawyer Pong, then Marietta, the former learned Attorney General. I drew the attention and they stopped. But then, from nowhere, you also jump in onto the fray and you made certain scandalous statements which the bench thought that it was least expected of somebody who held a very high office as the leader of the bar when the Attorney General was not present. The Bar Association is just an association, but the Attorney General is the head of the bar. Yes, in every common law jurisdiction. So that is one of the enviable positions at the bar. Yes, I know the lead counsel was a president of the bar, but Attorney General, somebody who has acted as Attorney General, is the head of the bar, not the Bar Association president. And we want you to tell us whether you did say those words. Then you proceed from there.
My Lord Chief Justice, I did say those words. My attention was drawn to the fact that I might have crossed the line by Mr. Frank Davis. And Your Lordship, on the advice and consultation with my counsel, I have written to the court rendering an unqualified apology. I delivered that letter this morning to the Registrar of the Supreme Court to bring it to Your Lordship's attention.
We have copies of the letter and we've circulated it. Yes, we are comfortable with the apology, but we want to make certain consequential of this. Yes, Mr. Beecham. Yes, you can be heard.
Yes, my Lord. With respect, our client has no excuse. Personally, as lead counsel for him, I was very disappointed at the article that I read last week and was deeply distressed when he called me last night. And I thought it was because I had made certain disparaging remarks expecting some action to stop this canker in the profession. It was to tell me that he had realized the error of his ways and pleaded for me to join him to render an unqualified apology to this court. He makes no excuses for that. He admits he is wrong and has been wrong. He deeply regrets the harm done to his profession, the disrespect shown to the court and to also to the country. I have his instructions to render his unqualified apology to every member of the Supreme Court and indeed the judiciary of Ghana and the legal profession and people of Ghana that he is awfully sorry for what he has done. He is deeply remorseful and he deeply regrets what he's done. So, my Lord, our prayer is, yes, true justice has to be done, but we ask you to temper justice with mercy.
You are a former president of the Ghana Bar Association, is that right?
That is so, my lord.
I have been worried for some time now, listening to people granting interviews to the media, and not any ordinary people or lawyers, but people who have occupied very high position in this country. And we have to decide where we want to go as a country. In my view, the only reason why Article 88 of the Constitution, or the only ministerial position which is provided for in the Constitution, is that of the Attorney General, is that when you are appointed an Attorney General, you are appointed an Attorney General for the whole country. A party or a president may appoint you as Attorney General, but once appointed, you are the Attorney General for the whole country. And you are to ensure that every citizen of the country is given justice or has access to justice and fair trial. So when I hear former Attorney Generals and Deputy Attorney Generals mount or grant interview and make certain statements aligning in no uncertain term to one political party, it's something that worries me. And as a former president of the bar, I think you have to open a debate in that area about the proper role of attorney generals or former attorney generals, having regard particularly to Article 88 of the Constitution 1992.
Man of respect.
Two lawyers to support you. What we can do for your client is to let him go back and purge the contempt. Yes, he spoke to the whole world on television. Yes, he should tell the people that he's very, very sorry. What he did was wrong, and that is all. We are not going to find him, we are not going to give him a bond, but at least coming from somebody who has acted an attorney general, if we don't take any action, it is going to send dangerous signals elsewhere. That is all what we want to do for him. So if he does it today, the court will assemble on Thursday and just strike out this matter. That is all. We are not exacting any serious punitive would I say measures against him. All what we want to do is for your client who has confessed to whatever he did to he just go and apologize for the harm that he has caused to the profession and to the bench. This is our profession. Nobody can come from elsewhere to make it better. Yes, beyond the lawyers, nobody can come from elsewhere to make it better. Yes, we can make it. And it is a duty which has been imposed on us by our call. Yes, so please, let's all cooperate. At times you hear some comments by lawyers and you feel that they are killing the profession, because a time will come when nobody will come and sit here as a judge. Yes, we posted one judge to ECOWAS court as a high court judge. He's not the president. Whereas the other countries posted their Supreme Court judges there. A high court judge from Ghana was the president there. But this is Asante. We had a court of appeal judge here. He sought the leave of the Chief Justice to take outside appointment. He's the Chief Justice there. And no matter what we do, please, the profession first. Yes, the profession first. And we should endear ourselves to the respect and whatever it will take to bring the profession to its past glory. So we thank you very much for not dragging this matter and coming with an unqualified apology. So that is what the bench has decided. We don't want anything from the former Attorney General, Deputy Attorney General, but all what we want is the retraction, yes, an apology, yes, through the same medium, and that will end the matter. If he does it, we'll come here on Thursday and have it struck out.
Because we are very grateful to you for this indulgence, and also taking the cue from the point made by my Lord Amugati, whose views I share personally on a personal basis. And I did indicate to you why I stepped in, because I was even more worried when he called me. I thought someone had accrued that I had made disparaging remarks about his comments, but that's the point. But the right to be done, Lord. And we are profoundly grateful for your indulgence, and promise you that even before we came here, we had started a process of showing remorse and regret. Most grateful, my lords.
I will say something small, because Mr. Dr. Aine is a friend and a brother to me. I know he is a member of parliament and therefore a politician. But he should know how to talk when he is addressing the press as a lawyer, and then how to talk when he is addressing the press as a politician. They are two different things, because I know when politicians mount the witness box, they say anything, they can say anything at all. Then at the end of the day, when they are recorded, they come to deny. I've been a politician before. I know how it is. So you should know how to talk as a politician and then how to talk as a lawyer. They are different things altogether. Besides, we've been insulted, judges are insulted by people who know nothing about the law, and sometimes who know nothing about the issue that is before the judge. And they talk and insult. If they are not lawyers, we don't care. Because if you don't want to be insulted, you cannot be a judge. But if you are a lawyer and who knows the law and who knows the procedure, and then you talk, in a manner, that does not speak well of you as a lawyer, it gives opportunity to non-lawyers to also talk or say worse things. So that's my advice to him as my brother. I'm a younger brother.
Yeah, you know what they have done for them. I remember when we went to the country. Ask him. I called him, and he was prepared to go to the news file to explain what obtains at the various faculties and why people should pick and choose and put their wards and children there to study law, not any faculty without lectures and whatever. And yes, the bench approached you, and you did it for us for free. Yes, so these are some of the things that we can all, do to help the profession. It's nothing more. Yes.
So we are really grateful, and thanks for that.
And just one more thing from me. Mr. Dr. Ayeni, as a former Attorney General, I have sat with you on the Judicial Council before. The two of us have joined to even appoint justices of the Supreme Court. The challenge, the difficulties, what we went through to appoint justices of the Supreme Court for this country. So after serving the Republic in that light, it's improper for you to go and make those statements to give the impression that the justices make decisions based on certain things. That's why some of us are disappointed at that statement. But having rendered this apology, we know, as my brother Justice Apau said, sometimes out of some kind of excitement or so, you are forced to make certain statements. As we've said here, we all make mistakes. We are human beings, and once in a while we cross the line, we make mistakes. So I'm happy that at least you've realized that what you said was overboard and you are prepared to retract it. But going forward, let's remember that we have one country and we all have a responsibility to keep this country together, no matter the circumstances and the situation we are confronted with. Thank you.
Lord, we are grateful for the admonition. I promise you, this will not occur. I'm grateful.
Yeah, my court.
Yes, my lords, with all due respect.
Yes.
My lords, before this matter comments, your lordship mentioned my name. My lord, with the greatest of respect, with all respect to this court, I just want it to be placed on record that I have not said anything to scandalize this court. I believe that...
I didn't say so. What I said was that when we started the proceedings, you were granting interviews, and we drew your attention to the new legal profession ethical rules. Yes, we drew your attention to it, and you were advised to stop, and you did.
My lord, your lordship, I no doubt disputes that.
Yeah.
But I think before the proceedings,
I never said you.
Something was said to that.
Oh.
Myself and.
Yeah. And
my lord, if that is the position of the bench, yeah. I'm exceedingly grateful. I don't want my name to be associated with scandalizing this court. As a former president of the Great Accra Bar, the longest serving president of the Great Accra Bar.
And the most populous bar.
Yes, and the most populous bar, arguably. Justice Amigache is not looking at me. I was the Mugabe of the bar, and I remain so. Yeah. I'm grateful.
Yeah.
I'm grateful.
I thought you were the Nkoswaimi.
Yes, Prof, you can call me that. That was conferred on me by the Sanzini Amisha as a Nkoswaimi of the bar, so I still remain.
And we take this opportunity to also thank you for your end of year dinners for the bar. For the bar and the judges.
So far as that is concerned, Justice Apo can bear ample testimony.
So thank you.
With my eloquent service of blue label Scotch whiskey.
Thank you. Yeah, thank you. This is the order of the court. We accept the apology of learned counsel for the contempt law. We, however, order that the contempt law purges its contempt by retracting the scandalous statement on the very same medium before Thursday, the 25th of February 2021, when the court will reconvene. The contempt proceedings is thus adjourned to Thursday, the 25th February 2021 at 9:30 a.m. So, Mr. Bicham, so you will come here 9:30. If he renders the apology, you will come and completely vacate the order.
My Lord, just for some clarification.
Yes.
I don't believe we are expected to be here on Thursday. No, we just want to be, yes. Very well.
If you want to come and show solidarity, you are invited, you are at liberty to attend. So.
All rise.